You got that green chair, man. Don't ask no officers, what happened? Y'all better pay attention to y'all shit. We not paying attention to y'all shit. I gotta pay attention to y'all.
Afternoon, everyone. I hope everyone's doing well this afternoon.
Good afternoon.
Good afternoon. Good afternoon, Your Honor.
Good afternoon, Your Honor.
Thank you. Let's see, Courtroom Two, where we're gonna start today.
Good afternoon, Judge Morrow. This is going to be position 2, Mr. Clark. He's a private attorney case.
Okay, thank you. Good afternoon. Let's see. And who's representing Mr. Clark?
Good afternoon, Your Honor. I am, first name's Curtis, last name is Hubbard.
Good afternoon, Mr. Hubbard. Let's see. Good afternoon, Mr. Clark. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Sure.
Thank you. Mr. Clark, you've been charged in case 22 CR 004872G with theft by taking and 2 counts of theft by taking. Is there a history, Mr. Howard?
Did he go to felony first appearance too?
He did. This is Curtis Hubbard speaking on his behalf. I represented him on felony first appearance this morning. He was granted a total of a $30,000 bond.
Judge, my coworker got that file.
Okay,
Your Honor, I can go over the history.
thank you, Ms. Falk. Good afternoon.
Good afternoon, Your Honor. What we are showing, I had the most relevant history, but I also want to kind of go back a little bit on his history. So what we are showing in his history is, Your Honor, will just give me a moment. We are showing 6 cycles on this defendant's history. A battery family violence where the defendant was found guilty on October 2016 in DeKalb County State Court. He was given 12 months probation. He was then arrested in December of 2018 for theft by taking, financial transaction card fraud, and identity fraud here in Fulton County. That case was then accused as 19 SC 169872, for which he then bench warranted on that case. And that is, he was arrested on a bench warrant on that case, and he's in custody for that as well as this case. Then he had an arrest for possession of firearm during commission of a felony and theft by taking. That arrest was on January 5th, 2021. That is an open, unindicted case under 21 CP 196594. We then have the theft by taking that occurred yesterday, the 2 counts of theft by taking for which the defendant is now before this court. And there's a failure to appear, but that was from that 19 SC case that the state has already referenced.
Okay.
May I continue with the facts?
Yes, I want to clarify on my calendar, it has 2 theft by takings, but the date is 2/2/2021.
2021. That is correct, Your Honor. He was arrested yesterday. However, the events happened back in February of 2021.
I understand. Thank you, Ms. Falk. Go ahead.
Not a problem, Your Honor. This incident happened, well, police actually made contact with a Miss Ryan Williams, who stated on February 3rd, 2021, that her mail had been stolen the previous day, February 2nd of 2021. The way she was notified about it actually was that her next door neighbors had Ring cameras, and the Ring cameras had seen a vehicle driving down the street, stopping at each house along the route and looking into mailboxes. Miss Williams, interestingly enough, has a service with USPS that tells her what mail is scheduled to arrive at her home. She had a credit card statement that was scheduled to arrive, a bank statement, financial statements, and a personal letter that did not arrive due to them being removed from her mailbox. Officers conducted an investigation and located a second victim by the name of Robin Creech. Miss Creech also had her mailbox rummaged through, which was also captured on the Ring video by the same suspect vehicle that was seen in the Ring videos in Miss Williams' case going down the street. Miss Williams was also had notice of what mail items she was scheduled to receive. She had a credit card statement and a social security statement, which she did not receive. A license plate reader was actually used to identify the suspect vehicle in this case. The vehicle came back to a person by the name of Courtney Montoya. And Courtney Montoya did state that her child's father, Mr. Clark, the defendant, did borrow the car at one point. And she stated that she had bailed him out of jail back in January when he was arrested for theft by taking. Officers then used that information to locate the arrest for theft by taking, of mail back in January 5th of 2021 in Roswell. And in that case, the defendant was stopped during a traffic stop and had a large black trash bag full of mail, which belonged to various residents of the city of Roswell. So that had occurred, that stop in January of 2021 had occurred about a month before our case. They were able to then get subscriber information for this defendant and showed that his phone was pinging in the area that the mail was stolen in our case in February of 2021. As Your Honor has already heard, this defendant has two open cases both in the DA's office. One is that 19 SC case where he was given a pretrial release bond and then was taken back into custody because he bench warranted on that case. That was the theft by taking, financial transaction card, and forgery. He also has the open pending case, that 21 CP case for theft by taking and possession of a firearm. He received a $30,000 surety bond on that on January 6th of 2021. And then less than a month later, he committed these offenses. The state is requesting a $10,000 surety bond. We are requesting a $5,000 surety bond on each charge. He already has a $2,000 surety bond on this case, $1,000 on each charge. So we are asking for an increase. The reason why is obviously because the defendant has multiple open cases already, and he failed to appear on his 2019 case, which does show that he is a risk not only of reoffense, but of failure to appear. We are also asking that he stay away from the addresses at 215 Gabriel Drive and 880 Brooks Glen Drive in Roswell, Georgia. We are asking that he have no further contact with Ryan Williams, and that's common spelling R-Y-A-N Williams, and Robin Creech, Robin common spelling Creech C-R-E-E-C-H. That is, and we are also asking, and I know we normally don't ask for this, an anti-theft class given the circumstances and given the number of cases. That is all for the state.
Thank you. Mr. Hubbard?
Yes, Judge, just briefly, Mr. Clark is a native of the state of Georgia, lifelong resident of the state of Georgia. He is 30 years old, Judge, although he will be 31 this Thursday. His birthday is July 28th. He was arrested 2 days ago, Judge. He was actually at work. He delivers for a company called New Concept Couriers. So he was in the process of delivering and working when he unfortunately ran a red light. And as a result of that was arrested. That actually occurred in Cobb County, and then he was transferred to Fulton County. I appeared with Mr. Clark this morning as it relates to 19 SC 169872. He had a first appearance in felony court this morning. He was granted a total of a $30,000 bond by Judge Rashida Oliver. So essentially she reinstated the old bond, but he has to make the $30,000 bond with similar conditions that the previous $30,000 bond carried. He is a 2009 graduate of Cedar Grove High School, has actually taken some courses in audio engineering from the SAE Institute. He supports 2 children. I would be asking the court, in light of the fact that he has to make a $30,000 good bond on the 19 SC case. And keep in mind, Judge, that although he's got 6 cycles, what I did not hear was any felony convictions. I did hear the one misdemeanor conviction, but I would respectfully ask the court for for a total bond of $8,000, which would be $4,000 per count, and I have no opposition to the other special conditions that Madam Solicitor requested.
Your Honor, I would also be remiss, and I failed to point this out, that when he was arrested back in January, he did have an outstanding warrant out of Cobb County for theft of mail as well. We're unsure what has happened with that outstanding warrant. It's not showing up on our jail record as him needing to be transported to Cobb County at this time. As for the contention that this defendant already has to make a $30,000 bond, my response to that would be he wouldn't have had to make a $30,000 bond if he had simply shown up for court in 2021 and avoided a bench warrant.
Okay. Thank you, counsel. For each count of theft by taking, it's going to be a $4,000 good bond, making for a total of an $8,000 good bond. No further contact with Ms. Creech or Ms. Williams. Stay away from the Gabriel Drive address and the Brooks Glen Drive address, and no drugs, alcohol, or weapons while out on bond. Anything further on Mr. Clark?
Nothing further on behalf of Mr. Clark, Your Honor.
All right. Good luck to you, sir.
Thank you. Everyone stay safe.
Yes.
Thank you, Mr. Hubbard. Thank you, Your Honor.
Position 19, Rutledge.
Good afternoon, Mr. Rutledge. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Rutledge, you've been charged in case 22 CR 004885J with simple battery and criminal trespass. Is there a history, Mr. Howard?
43 total. Last arrest was back in June, probation violation out of Clayton County. He's on probation there for possession of meth. He has several probation violations, a couple of FTAs, 2017 simple battery NOLO, 2017 simple battery conviction, 2017 simple assault NOLO, 2017 FTA for shoplifting, another 2017 FTA for shoplifting, and another one. That's it. He got probation violations, like I said, burglary and enter and auto convictions and all that stuff.
Thank you. Is this your case, Ms. King?
It is, Your Honor. Good afternoon.
Good afternoon.
On yesterday, Mr. Coy Dumas, who was the victim in this case, COYDUMAS, told the MARTA police that the defendant threw a beer can at him and it hit him in his back. And this occurred while he was entering the Westlake MARTA station. The defendant was ultimately apprehended at a Chevron gas station a couple of blocks away from the MARTA station. Upon capturing him, they discovered that he had an active MARTA suspension in the system. The state is requesting a $6,000 surety. That's $4,000 for the simple battery and $2,000 for the criminal trespass. A stay away from the Westlake MARTA station located at 80 Anderson Avenue in Atlanta. No further contact with the victim, Mr. Coy Dumas, and no drugs, alcohol, or weapons while out on bond. The state is gravely concerned in this case. This is a random act of violence. The victim does not know the defendant, and it's our contention that the defendant doesn't know the victim as well. The defendant has multiple criminal trespass convictions on his record, showing that he will not listen to the orders of the court and will not follow the law. And as pretrial already said, he is also a convicted felon. He has convictions even this year, 2022, 2020, 2019, 2018, going back, Your Honor, every year. Even some years he has multiple convictions. For that reason, we feel the $6,000 surety is more than reasonable.
Thank you. Good afternoon, Ms. McLeod.
Good afternoon, Your Honor. My client is 30 years old. He is a native of Atlanta. He is not currently employed, Your Honor, simply because he is not able to work. He tells me that he has been diagnosed with certain disabilities since he was in the 4th grade. And I think that impacts a lot of his behavior, Your Honor. He does tell me that when he threw the can, he wasn't throwing it at this person, Your Honor. He was just throwing the can, and it happened to hit this person. So he was very sorry for that, because he does not, in fact, know this person, and he was not attacking him. He was just tossing the can, and it happened to hit him. He's in no position to pay a bond, Your Honor, because, as I said, he's unemployed. He tells me that he's supposed to be receiving SSI soon, but he has been disabled for some time, since the 4th grade. And I would ask the court to take that into consideration in setting a bond for him. I understand that there has been many cycles, but it seems to be that he has not received some of the help he needs from the system. He's just been cycled through the system without anyone taking into consideration that he has certain disabilities. And I would like the court to consider that in setting his bond. Thank you, Your Honor.
Okay. It's going to be $1,000 good bond for each charge, making for a total of a $2,000 good bond. No further contact with Mr. Dumas. Stay away from the Westlake MARTA station, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Thank you, Your Honor.
Good luck to you, Mr. Dumas. I'm sorry, Mr. Rutledge.
Position 8, Mr. Harris. Put that mask up for me, Harris.
Good afternoon, Mr. Harris. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Harris, you've been charged in case 22 CR 004877F with criminal trespass, public drunk, and obstruction of the law enforcement officer. Is there a history, Mr. Howard?
C1 total. Last arrest was 2021, probation violation. He's on probation, ag assault, 2 counts. Case number 18 SC 157228. 2020 parole violation. Another 2020 parole violation. We got a lot of probation. 2015 criminal damage to property, 2nd degree conviction. More probation. 2015 obstruction conviction. 2015 ag assault obstruction conviction. You want more?
You're fine, Mr. Howard. Afternoon, Mr. Dudley. Is this your case?
Yes, I'm handling this one for the state, Your Honor.
Okay, you can proceed.
This incident occurred on June 23rd, 2022 at 3950 Cascade Palmetto Highway in South Fulton. The defendant, Marvin Harris, attacked the victim, Latoya Dunn, spelling first name Latoya, last name Dunn. Ms. Dunn was at home with a male visitor when the defendant came home drunk.
I do apologize for interrupting. I want to be sure that we're on the right position.
Same for the state. Is this John Harris or LaMarvin Harris?
This is John Harris, position 8.
So that's my case.
I thought that was LaMarvin Harris.
No, no problem, Mr. Dudley. We just have a number of people with the same last name, so it's going to get a little confusing. My apologies, Your Honor.
Okay, so criminal trespass, public drunk, and obstruction.
That is correct.
Okay, go ahead.
We did, I just want to put on the record for the jail, we did do a not on docket for the disorderly conduct. So we did send that over to the jail and to the defense, so they should have that. So this occurred on July 25th of 2022 over at the 5 Points MARTA station at 30 Alabama Street Southwest in Atlanta. What happened in this case is that officers were contacted by multiple patrons who stated they witnessed the defendant in a verbal argument with an unidentified female. So once the officers went over to that location, the female was not on scene, but they went up to the defendant to ask him to leave the MARTA property before giving him also gave him, an official criminal trespass warning. At that point, the defendant became very aggressive and belligerent toward the officers. They tried to escort him off the property. There was a strong odor of alcoholic beverage on the defendant's breath. As they were able to actually remove him from the property. Unfortunately, Mr. Harris then returned back to the property. And at that point, the officers, after having given him a criminal trespass warning, went to place him under arrest. When they tried to place him under arrest, he began struggling with the officers, biting, trying to bite at them, kick at them, and attempting to spit on the officers. He also threw himself onto the ground, refused to walk or stand. And at that point, they did fully take him into custody, and that is why we are here. The defendant actually has currently a $10,000 surety bond on this case. They did assign a $2,500 surety bond on each charge. I think that is in large part because the defendant's extensive history, as well as multiple probation violations, multiple parole violations. I think the pretrial kind of summed it up by just the number of cycles, the sheer number of cycles on this defendant's history. We are requesting, however, that be lowered to a $5,000 surety bond. That would be a $6,000 surety bond, which would be $2,000 on each of the charges, $2,000 on the public drunk, $2,000 on the obstruction, and then $2,000 on the criminal trespass. We are also asking that he stay away from the MARTA station located at 30 Alabama Street, and that he have no alcohol, drugs, or weapons. Thank you.
Thank you. Let's see. Good afternoon, Ms. Gannett.
Good afternoon, Your Honor. Mr. James Harris is 43 years old. He has been in the Atlanta, Georgia area his entire life. He does have family here in Atlanta. However, he doesn't have anyone to assist him. He is homeless, Your Honor, and he informs me that he has an appointment on August 4th. He is in this program to get him housing, and it's through the courts, he tells me, and that he does not want to lose this appointment. Your Honor, Mr. Harris completed the 11th grade. He is unemployed at this time and has been so for the past year. Therefore, he is unable to pay anything toward bond. I would ask that you take into consideration the nature of the offenses, Your Honor, and my client's means to pay, considering if he misses that appointment, then will more likely set him up for more trouble, if you will. He denies the allegations. And lastly, I am requesting that signature bond, and I am opposed to any stayaways at the MARTA location unless he has an active suspension. Thank you, Your Honor.
Okay, it's going to be $1,000 good bond for each charge, a $3,000 total good bond. Abide by any active MARTA suspensions, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Harris.
Next,
Thank you, Your Honor.
position 22, Mr. Woods.
Good afternoon, Mr. Woods. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Woods, you've been charged in case 22 CR 004887C with battery family violence. Is there a history, Mr. Howard?
I don't have that one either. My coworker got that one. Because he went to felony as well.
And Ms. King?
Yes, Your Honor. This is his second arrest. His other arrest is the felony case pretrial was referencing.
And what was that charge?
It is driving without a valid license and a felony drug charge.
Okay, thank you.
Thank you, Your Honor. This offense occurred on November 10th of 2020. Officers was dispatched to a dispute call at 2370 Herring Road Southwest. Upon arrival, they spoke with the victim, Ikesia Wells, IKISA Wells. She advised that her stepson, who was the defendant, who lives in the home with her, was sitting on the front porch when she told him to go across the street due to the dog being on the porch. He refused, and she grabbed his arm to get him to go. At that point, he punched her in the face several times and also in the stomach. She advised that after he punched her, she went inside of the home, and he remained outside and went towards the rear of the house. She reported that while being inside and him being outside, she heard several gunshots. Neighbors that live nearby, I want to say it's either the house next door or a couple houses down, stated that they saw the defendant go toward a vacant property located in the back of the house. And they also advised that they heard the gunshots. Officers, when their officers arrived on the scene, he was not there anymore and they canvassed the area and did not locate him. I'll also like to let the court know they did not find shell casings. The officers stated that they saw a laceration on the inside of her lip, along with, a bloody nose that resulted from the punch in the face. And all of these injuries were identified on his body-worn camera. The state is requesting a $4,000 surety, no further contact with the victim in this case, a stay away from 2370 Herring Road Southwest, and no drugs, alcohol, or weapons while out on bond.
Has anyone from your office spoken with Ms. Wells?
Yeah, I did, Your Honor, but go ahead.
Okay, I wanted
So
to.
we called and left a message and sent a text. It is my understanding that we have not heard back from her.
Okay, thank you. Ms. Kim, good afternoon.
Good afternoon, Your Honor. I believe his family was going to be on the Zoom. However, I had a chance to talk to his father and his stepmother. They are not afraid of him and they are okay for him to return home. And this happened about 2 years ago, Your Honor. It has been a long time and they are already reconciled and moved on from this. He is 20 years old and Mr. Woods he was born and raised here in Georgia. He does not have a children. He's not married. He lives with a father, stepmother, and 2 siblings. He is actually going to 12th grade and he's pursuing GED to complete the last semester of the 12th grade. And I believe that he should be qualified for signature on bond on this particular case. We would like to request for signature on bond. Thank you.
Okay, it's going to be a $4,000 signature bond through the jail, no further violent contact with Ms. Wells, and no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
Good luck to you, Mr. Woods.
Thank you, Your Honor.
You're welcome.
Position 20, Riles.
Good afternoon, Mr. Riles. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Riles, you've been charged in case 22 CR 004888D with simple battery, family violence, and hindering a person making an emergency telephone call. Is there a history, Mr. Howard?
13 total. Trespass conviction from 2020, Rockdale County. 2018 simple battery DV NOLO. 2017 simple. 2017 simple battery cruelty in the 3rd conviction. He had a 2017 ag assault. I think it was dismissed. Yeah, it was not processed. 2012 battery DV conviction. 2009 probation violation for burglary. And he just got the open case in the cab from September 2021. It's an open battery.
Thank you. Ms. King?
Yes, Your Honor, and I'd like to note for the court, the battery family violence conviction from 2012, the simple battery and cruelty to children conviction from 2019, and the simple battery family violence from 2019 that he pled NOLO all involved his ex-wife, not the victim in this case, but the open one in the cab, I was able to confirm that it is the same victim of this case, Your Honor. I spoke with them this morning and they intend to fully go forward with that case. On the 24th, officers responded to a dispute at 127 Shadow Creek Court in Fairburn. Upon arrival, they met with the victim and Ms. Brittany Duval, and the defendant was also there. The victim said they were standing outside of the residence after taking a ride around the block, and they started to argue. And the victim also noted threatening text messages from earlier in the day from the defendant's brother. Stemming from the argument that they were having. And the victim states that the defendant got in her face and stated, "You could be dead right effing now. And at that point, she went to grab her phone to call 911. And at that point, he grabbed the phone from her and threw it. The victim proceeded to run out of the door at that point to get a phone from a stranger to call 911. And she was successful in calling that time. At that point, the defendant came outside and took her car keys out of her hand and left in the vehicle. The victim stated that she feared for her life, and she was not able to locate her phone after that. She also stated that their 15-month-old child was present at the time of this altercation. And also there were strangers, independent witnesses that witnessed this altercation as well. Ultimately, they were able to apprehend the defendant and put him into custody. We spoke with the victim and she stated they're married and live together and share 2 children. And she said she's very fearful of him when he acts like that. And she states that he needs some type of therapy or counseling. She also stated this is the 3rd time this has happened. And she did confirm that there was an open case concerning her in Stone Mountain, as well as that the other cases involved the ex-wife. Furthermore, Your Honor, they have a Zoom hearing on this coming Thursday for another violent altercation between them, but he only received a citation in that case. That case occurred last month. It is unknown to the state why he only received a citation, especially with his history, but they will be on Zoom dealing with that on Thursday. She states that she's not comfortable with a third-party transfer of any kind, and she does not want any kind of contact with the defendant, and she does not want him returning to the home that they shared. Your Honor, we are gravely concerned. He's been very violent, not only towards her, but to previous partners. It's clear. So he got the first battery family violence from DeKalb. And while out on bond on that one, she had to call 911 on him again, which is the case from last month. And while waiting to deal with that, he, assaults her again on 2 days ago, Your Honor. For that reason, we're asking for a cash bond. The state requests a $7,500 cash bond, a stay away from the incident location, 127 Shadow Creek Court in Fairburn, no contact of any kind with Brittany Duval. That's third party, family members, any sort, Your Honor, and no drugs, alcohol, or weapons while out on bond.
How's that broken down, Ms. King?
$7,000 for the family violence charge and the $500 for hindering 911 call.
Thank you. Ms. Kim?
Yes, Your Honor, Mr. Riles, actually, he is 37 years old, and he says that they are actually separated and they don't live together. 127 Shadow Creek is where he resides, and Brittany Duval lives somewhere else. They have 2 children. One is 1 year old, 15 months, and another one is 6 months old. Mr. Riles has been here in Georgia for 30 years, and other than those 2 children with Brittany Duval, he has 2 other children, total of 4 children, and he's currently not married. And he has his siblings here in Georgia, and he believes that he just lost his job because of these arrests. He's afraid that he's not going to be able to go to his company where he was a truck driver. He was working there for 3 years, and he wants to get back and try to convince the employer to rehire him. He has a GED, and he would like to, I do understand there's another open case pending. So we would like to request for $1,000 maximum surety bonds for each charge, totaling $2,000, Your Honor. Thank you. Not the cash bond, but surety bond, Your Honor.
All right, so for the simple battery, it's a $3,000 good bond. For the hindering person, a $2,000 good bond makes for a total of a $5,000 good bond. Stay away from Shadow Creek Court, no further contact with Brittany Duval, and no drugs, alcohol, weapons while out on bond.
Your Honor, the Shadow Creek Court, he claims that that is his place. So can we have a one-time law enforcement escort to verify that she does not reside there and he can return to that place?
Okay, that's fine, Ms. Campbell. One-time escort. If Ms. Duvall is not there, then he's free to stay. If she is there, he'll have to collect his belongings and go somewhere else.
Yes.
Okay, good luck to you, Mr.
Thank you.
Ross.
Thank you, Your Honor.
Who do we have next?
Position 4, Mr. Felton.
Good afternoon, Mr. Felton. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good morning.
Thank you. Mr. Felton, you've been charged in case 22 CR 0048748 for simple battery. Is there a history, Mr. Howard?
41 total. He got history out of New York, North Carolina, Louisiana, and Mississippi. Hold on. I see a 2021 out of Louisiana for disturbing the peace. Possession of a drug without prescription. Illegal possession of stolen things. 2021 battery. It's 2 counts. 2017 public drunk. Another 2017 arrest. It says lewd conduct resisting officer. 2016 disturbing the peace. Possession of drug paraphernalia from 2016. Another 2016 disturbing the peace, resisting officer, public drunk. Hold on. That's out of Louisiana. 2020 Mississippi petty larceny. That was a conviction. 2017 public intoxication. Before that was a robbery in the 90s. Hold on, let me go to New York.
We also had a history out of Alabama pretrial. Do you see that at all?
Alabama?
Yeah, we had cycles out of Alabama as well. I'll go back and double check.
Nah, I just got Louisiana, North Carolina, and New York.
Okay, I'm showing cycles. I think it was 20 cycles out of Alabama.
What's the name on it?
19. Irvin Felton as well. It connected back to his when his
you know what?
NCIC, it connected to his NCIC, so it's all the same person.
Yeah, it does say Alabama.
Okay.
It's MS Police Department. I'm not sure what that is. Yeah, this history is extensive, so it seemed to be Veterans Day today. So that's about all I have.
Thank you. Ms. Fall?
Yes, Your Honor. So this happened yesterday at 141 Pryor Street, which is actually a voter registration building. When they arrived, they spoke to the defendant, who actually admitted that he struck Demetrius Durham, which is Demetrius, last name Durham, Durham. He said he struck him in the lower side of the face with an open hand during an argument with Mr. Durham. We are not clear on what the relationship is between Mr. Durham and the defendant, if there's any at all. We will state that, we did see the history out of New York, Mississippi. We also saw 19 cycles out of Alabama going from 1987 to 2020, 20 cycles out of Louisiana going from 1997 to 2021. He had a $5,000 surety bond that was set on him. I think that is due probably in large part, he only has one cycle here in Georgia, and that's this case. But I think it's due in large part to the fact that all of Mr. Felton's ties appear to be everywhere but Georgia. So I think the $5,000 surety bond was in recognition that he is an extreme flight risk, especially given that he has, I think, what I counted was either 4 or 5 state records that are not Georgia records and that are extensive. We are asking the bond remain as set. My concerns are that from what we're reading is that he struck a person he didn't know in the face, and that he has a pretty significant history outside of the state. So we do have concerns about his flight risk, his lack of ties to the community, and risk of reoffense, and that he just apparently walked up to somebody he was not familiar with and hit him during an argument.
Ms. Gant?
Thank you, Your Honor. Mr. Irvin Felton is 55 years old. He has been in the Atlanta, Georgia area for 1 year. He doesn't have any family here. However, he does have a sister that he reaches out to for support. She's unable to pay anything toward his bond, Your Honor. We are opposed to the stay away at 141 Prior Street. And we would ask that if Your Honor imposes a stay away, that it be such that he's able to go there for legitimate business. Mr. Felton is 55 years old. He served honorably in the Navy. He has been disabled for the past 7 years, Your Honor. This is not someone, my client did not just attack someone randomly on the street. My client states that the complaining witness, Mr. Demetrius Denham, he does not know him. He states that Mr. Denham was in the facility harassing people along with himself, and he felt threatened and he defended himself, Your Honor. I do acknowledge my client's history. However, I am, for this misdemeanor simple battery, requesting a signature bond on Mr. Felton's behalf, as he does not have the means to pay anything toward bond. And if Your Honor determines that he's ineligible, then a bond of no more than $1,000. Thank you.
And Your Honor, I did leave off the conditions. We are asking for no alcohol, drugs, or weapons. We were asking for a stay away from that location. If there is legitimate business he needs to conduct, then that is up to Your Honor whether you think he should be allowed back at that location. But it does not appear he works there. We are also asking for a BHET on this, just because given the volume of arrests and the types of cases, we do have some concerns.
Thank you. It's going to be a $3,000 good bond. Stay away from the 141 Prior Street address unless he's there on legitimate business. No further contact with Mr. Durham, and no drugs, alcohol, or weapons while out on bond. All right. Good luck to you, Mr. Felton.
Thank you, Your Honor.
Position 13, Jones.
Good afternoon, Mr. Jones. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
So,
Thank you. Mr. Jones, you've been charged in case 22 CR 004837F with battery. Is there a history?
Is this the dude from yesterday?
Say it again.
This the guy from yesterday?
He was supposed to be.
Okay, all right.
Yes.
Quentin Jones?
Yes, Mr. Jones.
Judge, you still want the history or?
Well, I don't have my notes from yesterday, so if you wouldn't mind.
This is 13th cycle. He's been in jail since May for entering auto criminal damage to property. 2019 FTA for obstruction. 2019 shoplifting NOLO. 2018 obstruction, it just says transferred to state court. 2018 failure to appear for trespass and possession of MDMA. The FTA says not prosecuted. 2017 marijuana possession. 2017 felony obstruction. 2012 robbery, probation violation, shoplifting. He went to prison after that 2012 arrest. 2012 probation violation, theft by taking. FTA for possession of marijuana. And the shoplifting conviction from 2012. 2009 theft by taking conviction.
Okay, thank you, Mr. Hart. Ms. King.
And Your Honor, he has a terroristic threats, cruelty to children, the third and aggravated assault conviction from 2019, for which he is still on probation for. He also has an open possession of firearm by felon, reckless conduct, open case 22 CP 210856, Your Honor. And it's my understanding he has not received a bond in that case yet. On the morning of July 22nd at around 3 a.m., an inmate, Fernando de la Rosa, was entering the cell where the defendant was located. And when he opened the door, the defendant ran aggressively towards him and punched him in the left side of his face, causing him to bleed profusely from his eyes and his nose. This did occur inside of in Rice Street Jail, Your Honor. The state is asking that the $7,500 bond remained as set and no further contact with Fernando de la Rosa.
Did I give it?
I'm sorry.
Did I give him that bond yesterday, Ms. King?
You did not. Wait, did you? I don't.
Yeah.
I think it was
It
already.
was set by Judge Williams on Saturday.
Yeah.
Okay.
It was
all right.
7,500.
Thank you. I appreciate that, Mr. Jordan. Go ahead, Ms. King, I'm sorry.
The victim's name is FERNANDODELAROSA.
Okay, thank you. Ms. McLeod?
Yes, Your Honor. My client is 37 years old. He has some college education. He actually has an associate's degree, Your Honor. My client tells me that he had been followed by some gang members for some time, and he was actually locked up for probation violation, and he was placed in a cell with the very same people who had been following him on the street. And he was attacked in the jail by one of these persons, and he was merely reacting to this attack, Your Honor. My client also tells me that he is currently homeless. So he is in need of housing, Your Honor. I do believe that my client has some other issues which he needs help with, because he insists that he has been followed for some time by gang members on the street, and that the reason why this happened was because of the same gang members were locked up with him.
All right, are you requesting anything in that regard, Ms. McLeod?
Well, Your Honor, I think he may need some mental evaluation. That would be my opinion. I'm not an expert, but it sounds to me like he genuinely believes that this is what happened, Your Honor.
Okay, if you're requesting a mental health evaluation, Ms. McLeod, I'm certainly will sign that order, if that's what you believe.
Thank you,
Yes,
Your Honor.
that is what I believe, Your
Joins
Honor.
the defense in that request.
Okay, all right, so that's what I'm gonna leave, at this point in time, I'm gonna leave the bond where it is, except that I'm gonna add the mental health evaluation to that. And there's, of course, the no further contact and the no drugs, alcohol, or weapons.
What's the
Thank you,
bond
Your
amount, Judge?
Said it's gonna remain the same at 7,500. Good.
Thank you, Your Honor.
Okay, thank you, Ms. McLeod. Who do we have next? Good luck to you, Mr. Jones.
Thank you.
Position 9, Mr. Harris.
And Ms. McLeod, if you will work with someone to get that order to me, if you don't have, if you're not able to, I'm not sure if you can or not, but if you wouldn't mind, I'm with Ms. Bridgewater today. Okay,
Yes, Your Honor.
all right, thank you. I'm sorry, Courtroom Two, who do we have?
This is position 9, Mr. Lamarvin Harris.
Okay. Good afternoon, Mr. Harris. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Harris, you've been charged in case 22 CR 004834C with battery family violence. Is there a history, Mr. Howard?
This is another one from Saturday. I don't have his history.
Okay. Mr. Dudley?
Yeah, this one's me, Your Honor.
Right, okay. Latanya Dunn and Cascade Palmetto Highway, I believe.
Yes, this incident occurred on June 23rd, 2022 at 3950 Cascade Palmetto Highway in South Fulton. The defendant attacked the victim, Latoya Dunn, spelling Latoya, last name Dunn. Ms. Dunn was at home with a male visitor when the defendant came home drunk. And after the male visitor left, the defendant and Ms. Dunn began arguing about the fact that she had a male visitor over while he wasn't there. At some point, the defendant began grabbing and pushing Ms. Dunn, who understandably started to defend herself. At that point, he began repeatedly punching her in the face. And as a result of that, officers were able to observe that both Ms. Dunn's eyes were swollen, her lip was busted, her nose was bleeding, and she had an abrasion above her left eyebrow. So for those reasons, the defendant was charged with battery family violence. Our recommendation, Your Honor, is a $7,500 surety bond, no further contact with Latoya Dunn, that the defendant stay away from 3950 Cascade Palmetto Highway in South Fulton, and that he have no alcohol, drugs, or weapons, Your Honor. The reason for this recommendation is that we are concerned with the risk of influencing Ms. Dunn, being that they are in a relationship or were in a relationship around the time of the incident. And we also have a concern about a risk of reoffense, as the defendant has a history largely out of California going up to the year 2008. He has had 11 arrests in California, with the bulk of his history being there. His most recent arrest was here in Georgia, and that was case number 22 CP 203109 for the offense of possession of controlled substance, trafficking in marijuana, and possession of a firearm during the commission of a felony. The reason we are concerned about the risk of reoffense is that the defendant was released on a $40,000 surety bond not even 9 months ago, and he was released in October of 2021, and here he is again today with this new case. For those reasons, the state is recommending the $7,500 surety bond. Nothing further from the state.
Thank you, Ms. McLeod.
Yes, Your Honor. My client is 41 years old. He is a veteran, Your Honor, having served in the United States Armed Forces for 4 years, where he worked as an aircraft mechanic. He tells me that he just started working at a new job, working at a company in Fairburn as a forklift operator. He is concerned about this job. He does tell me that he and the alleged victim have been in a 5-year relationship. They do not have any children together, but she has 2 children that he's been helping to raise. He also has 4 children of his own, Your Honor. He says that when this incident happened, apparently he was just they had gotten to an argument and he was trying to leave the house, and she held on to him, trying to stop him from leaving the home. Since the incident, which happened, I believe, sometime in early June, they have continued to live together, and she was unaware that there was a warrant out for him. I tried to contact her, Your Honor, because he had given me an email address. He had also given me a telephone number, which was not answered, because I really wanted to speak with her, Your Honor. I did try to send her an email, but the email bounced back. But he tells me that they have continued to live together since this incident, and this is a 5-year relationship. And just based on what I've heard, I was not able to properly hear his history because pretrial didn't have it. But just based on what I'm hearing, I don't believe that he has any violent history, Your Honor. And this is a 5-year relationship, and there has been no allegation that anything has happened between them before. And based on what the prosecutor has said, this arose out of an argument about some man being at the house, which is normally a trigger situation for most people in relationships. If a stranger or if another person turns up, it can cause an argument. And it sounds that this is what happened here. And my client says he really was trying to leave, and she tried to prevent him. Based on that, Your Honor, I would ask the court to consider giving him a signature bond, because I'm not aware of any history that he has in Georgia. I believe something was said about 2008 in California. We are now in the year 2022. Thank you, Your Honor.
Okay, let's see, is this Ms. Latoya Dunn that's under the Dunn family on the screen? Ms. Dunn, you're not required to speak. This is your opportunity to speak if you would like to address the court, but you're not required to. If you want to address the court, you'll have to unmute yourself and I'll have to swear you in. Do you swear affirm?
Good afternoon, Judge.
Good afternoon, Ms. Dunn. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, ma'am. What would you like to tell the court?
I would just like to speak on behalf of the situation. Me and Mr. Harris have had our differences during the pandemic, have lost loved ones on both sides, and we had an altercation that night that we have talked about and worked out through it was a misunderstanding. I was unaware that he had a warrant out. I see that he has no contact part. I really would like that to be dissolved. or we can do conflict resolution with that. We do have a blended family together. I have 3 kids of my own that he does help with. He's just started a new amazing job. I've been keeping in touch with them, hoping that he can keep his job. And I just would like you to just consider the no contact to be lifted off due to also us working things out, and I am pregnant. So I would like him to be part of a family, and we continue to work things out with each other.
Okay, this happened allegedly back in June of this year. Have you all been together since that time?
Yes, sir. Yes, sir. We have, and we have not had no problems at all, or no future problems coming.
Okay, so I take it you're not afraid of him?
Oh, no. No, I'm not.
And this hasn't happened before or since?
No. No, sir.
Okay. Anything further, ma'am?
No, that's it. Thank you, Your Honor.
Okay, you're welcome.
Your Honor, I would,
Yes,
like
Mr.
to
Dudley.
ask the witness a question.
Okay.
Ms. Dunn, is it true that the defendant had been drinking the night of the incident?
Yes, he has. And ever since that incident, he has sustained alcohol. We also has been doing AA. We're trying to find we just moved into our own home. We were basically misplaced during the pandemic and didn't have nowhere to stay for a while. So we're just moving and getting things situated. And he is aware of drinking and has been working on that as well. And we haven't had no alcohol issues or anything since then.
Okay, and were you struck by the defendant on the night of the incident?
It was more of a push, a shovel back and forth between both of us.
Thank you. Nothing further from the state, Your Honor.
Okay, it's going to be a $3,000 good bond, no further violent contact with Ms. LaToya Dunn, and no drugs, alcohol, or weapons while out on bond. All right.
Thank you, Your Honor.
Thank you, Your Honor.
Good luck to all of you.
Thank you.
You're welcome.
Position 17, Muldrow.
Good afternoon, Mr. Muldrow. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 004878H with criminal trespass. Is there a history, Mr. Howard?
42 total. Between Georgia and Illinois. I'll go with Georgia first. 2018 probation for disorderly conduct. 2016 shoplifting, it was a minute to disorderly conduct. 2015 driving without a valid license. Last arrest in Illinois was 2014 trespass to land. 2013, it just says ordinance. Another 2013 trespass. 2012 theft of services. 2012 theft of lost mislaid property. 2011 ordinance. 2011 theft of stolen property, 3 counts. 2010 possession of marijuana. 2010 trespass and a parole violation. Want me to keep going?
You're fine. Thank you. Mr. Dudley?
Yes, Your Honor. This incident occurred on July 25th, 2022, where the defendant was at Lenox Mall at 3393 Peachtree Road Northeast in Atlanta, Georgia, after he had been given notice of not being allowed on the premises. The defendant was approached by the officer and he was arrested. Prior, he had been arrested on July 30th of 2021 at the same place, at the same premises. And the case number for that is SG 702813-21. Your Honor, we will agree to a $3,000 signature bond and request pretrial services and that pretrial monitor him for a month, that he has to stay away from Lenox Mall and no alcohol or drugs or weapons, given that he has, as pretrial noted, numerous amounts of criminal trespass stating from Chicago, Illinois, and that he was recently arrested for trespassing at the same location not even a year ago, Your Honor.
You have any objection to that, Ms. Kim?
Your Honor, actually, he's recommended for signature on bond through jail. So if it goes to pretrial, it has to be by judge. I would like to defer to you, Your Honor.
Okay. It's going to be a $3,000 signature bond for pretrial for the judge. Stay away from Lenox Mall and no drugs, alcohol, weapons while out on bond. Mr. Muldron, if you go back to the Lenox Mall, they're just going to pick you up again and you won't get out on a signature bond next time. You understand?
Yes, sir.
All right. All right. Good luck to you, sir.
Yes, sir.
Thank you. Thank you, Your Honor.
You're welcome.
Position 21, Mr. Williams.
Good afternoon, Mr. Williams. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Williams, you've been charged in case 22 CR 004886B with battery, family violence, and cruelty to children in the third degree. Is there a history, Mr. Howard?
2020 trespass conviction, trespass out of Mississippi. 2008 probation violation out of Tennessee. 2007 theft of property out of Tennessee. This is 5th arrest.
Okay, nothing violent?
Not that I saw. I don't.
Okay,
I don't
thank
know.
you.
Hold on.
Ms. King?
Yes, Your Honor. On yesterday, the officers noted, when they arrived at the scene, noted seeing a visible mark and scratch above the victim's eye, Miss Chelsea Tate, CHELSYE, last name TATE. We had limited information, but fortunately we were able to get in contact with the victim. And she tells us that they've been in a relationship for 4 years, but they are no longer in a relationship after this incident and they share no children. She stated they had been arguing about their relationship for the past few days. And on the day of the incident, she went outside to take out the trash. And when she came back to the door, it was locked. She called her son, who was 15 years old, that was inside, to open the door. And when she got back inside the home, she asked the defendant why he locked her out. And he became angry and started yelling at her and getting in her face. At that point is when he poked her in the eye, which is the injury that the officer observed. She states that she also saw the defendant damage the door to the bedroom, which is now hanging off the hinges. She did not tell the officers that at the scene, which is why it was not charged when he was originally apprehended. At that point, she told her son, who was 15 years old, to call the police. And she states that the defendant looked at the both of them and said, if they call the police, I'm going to beat your A. Explicit. At that point, the victim states that the defendant pushed her to the ground and began striking her in the face and took her phone. While she says nothing like this has happened before, she at this point wants no contact and she wants him to stay away. She states that he has already retrieved all of his belongings, so there's no reason for him to return to the home for any reason. The stay away address is 1909 Cimarron Parkway, CIMARRON. It's in Sandy Springs. And the state is requesting a $5,000 surety. That's $4,000 for the battery, family violence, and $1,000 for the cruelty charge. No further contact with the victim, to stay away, and no drugs, alcohol, or weapons while out on bond. While he does not have a violent history, he does have a history among 3 states, Georgia, Tennessee, and Mississippi. So the state is concerned that he will not return to court. So the state requests the $5,000 surety for those reasons.
Thank you, Ms. Kim.
Yes, Your Honor. Mr. Williams is 38 years old, and he has been here in Georgia about 2 to 3 weeks. He moved to stay with Miss Chelsea Tate, and he has right now he's working at a temporary agency for maintenance work for about last 2 to 3 weeks. He has associate degree for HVAC, and he has one child of but they don't share children. However, he has one child and she has another child, and they don't have to share any child custody. They are not married. His parents are all in Tennessee, and so for him to get surety bond, if he gets a surety bond, his parents have to come from Tennessee, because apparently Chelsea Tate does not want to have any contact with him. So I really think he should get a signature on bond. He will come back and take care of this matter. He's not irresponsible, and his other charges are from 2008. That's very remote, and we would like to request for a signature on bond. Thank you.
Your Honor, to perfect the record, his last case is not from 2008. He has a 2021 conviction from Mississippi, a criminal trespass. So he last year was convicted of a crime in a different state, which is the reason for the state's concern.
By the way, the warrant does not even name the victim's name for the simple battery, family violence.
All right, so for the battery, it's going to be $1,000 good bond. For the cruelty, it's a $500 good bond, making for a total of a $1,500 good bond. No further contact with Chelsea Tate. Stay away from the 1909 Semi-Milan Parkway address, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Williams.
Thank you.
Position 6, Mr. Griggs.
Good afternoon, Mr. Griggs. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Griggs, you've been charged in case 22 CR 0048738 with battery family violence. Is there a history, Mr. Howard?
Oh.
Ms. Falk?
Yes, Your Honor. This incident occurred on July 12th of 2022 over at 3201 Downwood Circle, Northwest in Atlanta. This actually was reported initially by the leasing officer, who stated that there was a possible domestic dispute happening at the apartment at that location, and requested that the officers do a welfare check. So the officers went to that location. They spoke with the defendant. They actually did not see the victim, Miss Conception Flores. That is CONCEPTION. Last name Flores, FLORES. She was actually not in the apartment at the time, but the officer spoke to the defendant, and the defendant actually admitted to striking Miss Flores, with whom he lived with at the time and shares children with. He stated he struck her in the head, which caused a laceration to her face. Well, at the time, they didn't arrest the defendant because they did not have a victim and had not made contact with Miss Flores. However, they later found her in the lobby of the apartment complex. She had a bloody face and laceration to her head. And Miss Flores then told the police that she had been arguing with the defendant about finances. He grabbed her head, slammed it into the wall, and then for good measure punched her several times in the face. Officers then, having enough information to effectuate an arrest, went back to the apartment to arrest the defendant, but he had at that point fled the scene. Miss Flores was able to ID him successfully and state that he was the father of her child, and she was living with him at the time. So we have spoken to the victim. Although the defendant does not have a history, we got a pretty detailed statement from Ms. Flores, and she told us that the defendant has anger issues. When he gets angry, he lashes out. He takes out his anger on her. She said she fears the defendant because she does not know when he will lash out at her. He's controlling, and that he treats her like this because she's financially dependent on him. She stated that this isn't the first time he's hit her, but that this is the worst time that he hit her. And again, you have those officers who observed that laceration, observed her bloody face. You had a leasing officer who was so concerned he called the police, and you have the defendant who admitted to striking her. So this is not a he said, she said. There's pretty sufficient evidence that goes, or information that goes to a showing that this was a pretty serious offense. For those reasons, Your Honor, the state is asking for a $5,000 surety bond. We are asking for a stay away from that address, 3201 Downwood Circle. The victim has stated that the defendant has left the residence. However, we would just ask for that stay away. We are also asking for no further contact with Ms. Flores. That is, again, Your Honor, by her request. She is afraid of this defendant. She is concerned. And we are asking for one-day anger awareness. Your Honor, again, I know a $5,000 surety bond for a first offense is a high surety bond, but given all of the circumstances of this case and Ms. Flores' statement, which really reads like the cycle of domestic violence, we are really concerned about her safety and her well-being.
Thank you, Ms. Gant.
Thank you, Your Honor. Mr. Malik Griggs is 26 years old. He has been in the Atlanta, Georgia area his entire life. He shares a child with Ms. Flores, the complaining witness. Your Honor, that child is 1 year old. Mr. Griggs informed me that he and the complaining witness still live together. He indicated that he has not left the residence yet. He still wants to have contact. I did reach out to Ms. Flores, and she told me earlier today that she wants to have no violent contact with him. Mr. Griggs completed high school. He tells me that he's self-employed. He also, I guess, does some work as an independent contractor in the music industry, and he does DoorDash on the side. Your Honor, at this point, these are allegations. My client denies them. He is presumed innocent. He does not have any prior history. He has significant community ties. We did not hear about any failures to appear for any other traffic-related matters. I am requesting a signature bond as he is recommended. And again, we are opposed to the stay away. If Your Honor orders a stay away, we would ask for a one-time law enforcement escort. And again, we are requesting no violent contact. Thank you, Your Honor.
Okay, it's going to be a $3,000 signature bond through pretrial, one-day anger awareness, no further contact with Ms. Flores, stay away from the 3201 Downwood Circle address. He can go back to that address on one occasion with law enforcement to retrieve any belongings that he might have there. And there's to be third-party transfer of the child for visitation. Anything further, Ms. Gant?
Nothing further. Thank you, Your Honor.
Okay. Good luck to you, Mr. Griggs.
All right, thank you.
Position 18, Mr. Pulock.
Good afternoon, Mr. Pollack. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 004884E with simple battery family violence. Is there a history?
Third arrest. 2021 driving without a valid license, no low. And before that was an 01 arrest, but alcohol possession.
Okay, Ms. King.
Yes, Your Honor. Officers were dispatched to a domestic dispute at 235, Triumph Drive Northwest. Upon arrival, the officers spoke with the caller and the victim, Nancy Pollock, who was in her vehicle in the clubhouse parking lot in front of the community with her infant child with her. She stated that the defendant, who was her husband, who she also lives with and share that child with, had been drinking, and she was working with a therapist to get him into rehab. She states that he was not supposed to be drinking in the home. That was the agreement that was made between them. And then she asked him to leave the apartment. And when he stepped outside, she locked the door. At that point, the defendant knocked on the door and she let him back in. And she asked him again to leave when she saw the situation wasn't getting any better. She also stated that she attempted to push him out of the house with her hands. And at that point, he picked up a rock and hit her in the back with it. And then she states that the defendant got in her face and began to throw fake punches towards her, but did not strike her. She did state that she was fearful of that when he was swinging close to her face. At that point, the police were called and they arrived and he was detained. Now, while the defendant does not have a violent history, the fact that the victim is saying that whenever he drinks, he gets like this, that does concern us. She states that she doesn't want him to go to a rehab facility, which he has been approved to go to, Blue Ridge, but he has not gone on his own. So when she called the police, she wanted the police to take him to Blue Ridge, but they ended up bringing him into custody. The state is requesting a $2,000 surety bond, a stay away from 235 Triumph Drive Northwest, no further contact with Nancy Pollock, NANCY POLLOCK, and no drugs, alcohol, or weapons while out on bond.
Have you spoken with Ms. Pollock?
We have. She states that they are married, live together, and share a child. She did state that she never intended for him to go to jail. She just wanted him to leave the home and ultimately end up at the rehab facility, which is not what happened. But she did intend to call the police.
Yeah, I'm on the call too, actually.
Okay, I'll be with you in a moment, ma'am. Thank you.
Okay, sorry.
You're fine. Ms. Kim?
Yes, Your Honor. Mr. Pollock is 37 years old, and yes, they do live together. And the condo is actually owned by Miss Nancy. So he is willing to stay away from 235 Triumphant Drive. He actually expressed his interest going to rehab, Blue Ridge rehab, after if he gets out from here. He has an employment. He has been doing the solar development for last whole year. He has a bachelor's degree from Georgia Tech with honors. He's very smart, and he does not have any other violence history other than the fact that he is willing to go to Blue Ridge rehab. He's also recommended for unsecured judicial relief. So we would like to request for signature on bond through the pretrial so he can go to get the rehab that he needs.
Okay.
Your Honor,
Ms. Pollock, if you, just give me a moment, Ms. King. Ms. Pollock, if you want to address the court, you'll need to activate your camera, and I'll need to swear you in.
Okay, it says it's unable to access by camera. Can you hear me though?
Yes, but I'll need to see you, ma'am.
It says unable to access camera.
You will probably need to log out and then come back in, and when it asks you to enable your audio and video, you need to turn both of them on.
Okay. So go ahead and do that for us, ma'am.
Okay, so just leave and then come back in. Okay.
Yes.
I'll do that real quick. Okay.
Ms. King, you had something?
Yes, Your Honor. I was inquiring if one of the conditions is that he go to Blue Ridge. Can Your Honor order that he go to the facility since he's been accepted?
I think that was the ask from Ms. Kim also. Is that not correct, Ms. Kim?
That is correct, Your Honor.
Okay, if he goes to Blue Ridge, Ms. King, does that affect your recommendation as to the bond?
No, Your Honor. Due to feeling that they may treat the underlying issue that's here, I don't believe it would affect. I believe it would help. If anything.
Okay. Well, it may not help if he can't get out because there's a $2,000 good bond, but
I will defer to Deputy Falk if we will consent to a signature in this case.
Your Honor, I feel like you already know my answer on this
Oh,
one.
I did too.
Because it is family violence in nature, and because there is an allegation of violence in some form or fashion, we are not going to consent to a signature bond.
Okay, well, I try to get you all to consent when I can, so.
I understand, and we try to work with you when we can, but on this one, I just can't do it.
I understand, it's not a problem. Let's see, has Miss Pollock come back in yet?
She has not. She just texted me and said that she's not being allowed back in. I don't know what that means.
Okay, who are you're under the name of Patrick. Who are you, sir?
I'm just Michael's friend, Patrick. I've been trying to help Nancy, his wife.
Okay, thank you.
Judge, Mike, we can go.
I'm sorry. I just don't know if for some reason it won't let me access the camera.
All right, Ms. Pollock, what would you like to tell the court? First of all, if you'll raise your right hand, I will assume that you're doing so. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, what would you like to tell the court?
I just think that Michael is willing to go to a treatment facility, and that as long as he's doing that, that's all that I wanted in the first place.
Okay, and let's see, do you both live together at the Triumph 235 Triumph address?
Yes. Yes.
Okay, do you want him back there or not?
I just want him to go straight to the Blue Ridge treatment.
Okay, so once he gets out of Blue Ridge treatment, do you want him back in the household or not?
That's fine. Yeah, he's welcome to come back after.
Okay, are you afraid of him?
No.
All right. Anything else that you want to tell the court?
No. No.
Okay, thank you, ma'am.
Your Honor, could we amend the conditions to say that he can return to the home upon successful completion of the program at Blue Ridge? So if he completes it successfully, then go home, because if he doesn't, they'll be back in the same situation they were in before. Well, that's the state's concern, that they will be in the same situation again.
Okay. Any objection to that, Ms. Kim?
No, Your Honor.
Okay, so it's going to be a $3,000 signature bond through the jail. He must immediately go to inpatient at Blue Ridge. No further violent contact with Ms. Pollock. And he can return to 235 Triumph upon the successful completion of the Blue Ridge program. And of course, no drugs, alcohol, or weapons while out on bond.
Thank you, Your Honor.
You're welcome. Good luck to you, Mr. Pollard.
Position 11.
Thank
Mr.
you, Your
Hughes.
Honor.
You're welcome.
Yeah, man.
11?
Why do you indicate?
Let's see. Good afternoon, Mr. Hughes. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Thank you. Good afternoon. You've been charged in case 22 CR 004852B with battery family violence, 2 counts. Is there a history, Mr. Howard?
Yeah, this the guy yesterday you set a bone on.
Okay, and this was, and I believe at that time, where is Miss McLeod?
I am here, Your Honor.
Okay, this is your case, correct?
I did not hear his name, Your Honor. I'm sorry.
Mr. Hughes, position number 11.
Yes, Your Honor, it is.
Okay. And I specifically reset this case yesterday to make sure that somebody was here representing him.
Yes, Your Honor.
Okay, thank you. Ms. King, would you go over the facts again for me?
Yes, Your Honor. On July 24th, officers responded to a dispute with a weapon call at 643 Etheridge Street Northwest. Upon arrival, they met with the first victim, Ms. Tracy Lewis, who stated that she was attacked by a male who was identified as the defendant. She also stated that the defendant is currently involved with her niece, who is the second victim in this case, Amy Kent, AMIE. And she stated that they all live together in the home, the 3 of them. Ms. Lewis states that the defendant tried to have sex with her, and then when she refused, he got upset and started attacking her. And while she was being attacked, Ms. Kent jumped in to try to defend her. And at that point, he began to beat on the both of them. The officers noted scratches, abrasions, and bruises on the necks and bodies of both of them. And he documented that on his body-worn camera. And when they talked to the defendant, he kind of agreed that that's what happened, but he states he was just defending himself. But he did admit to striking the both of them. At that point, the defendant was apprehended. It is my understanding, I believe he gave him an $8,000 surety, $4,000 for each. The state asks that it remains as set. A stay away from 643 Etheridge Street and no further contact with Tracy Lewis or Amy Kent. no drugs, alcohol, or weapons while out on bond.
Okay, and have you all spoken with either Ms. Lewis or Ms. Kent?
As of this morning, no, Your Honor.
Okay, Ms. McLeod?
Yes, Your Honor, I actually tried to speak with Miss Kent. I called her and we were in the middle of a conversation and she hung up the phone. I think she didn't want to talk when I, started to ask her about what really happened. But I have spoken at length with my client, Your Honor. He is 54 years old. With regard to the property in question, Your Honor, that is my client's home. He owns that home and he lives there. He told me that the aunt, he had a restraining order against her from last year. She keeps coming back to his home. He says that she has assaulted him before, and that is why he did not want her to come to his house. He said that she came to his house on the night before he was arrested at just after midnight. She came there with his niece, even though the police had already given her a no trespass warning not to come back to his home. She does not live there at all. And he called the police when she came back there before, and they gave her a no trespass warning. Nevertheless, she showed up back again at the house. And this was when she attacked him because she was asking for $40 and he told her he was not going to give her any money. So she attacked him. That is what happened. My understanding is, Your Honor, that she has been arrested for attacking him before. There is a case where she has been arrested for attacking him. He did tell me that he had to get a restraining order against her last year. He absolutely denies the allegation that he tried to have sex with her, and he tells me that she has been continuously coming onto him and he has resisted her advances, and that is part of why she's angry with him. He doesn't want to have any contact with her at all, Your Honor. And he said he also had to have the mother evicted from his home. It seems to be a situation, the court probably will see that the girlfriend is 21 years old. My client is 54 years old. It seems like the family saw an older man who was interested in this younger lady, and they all decided to jump on the bandwagon to take advantage of him and what he has. Because this is his home, he doesn't want any of them to live there. He doesn't mind if his girlfriend lives there, but he does not want the extended family there, Your Honor. That is the issue as he sees it. They have attacked him in the past. Certainly the aunt, he says she's a drug addict, and she just keeps coming around trying to get money and other things from him and sex. And because he's come out against all of this, then this is what has happened to him. And Your Honor, I believe that his assertions have some credibility. And given the fact that the complaining aunt has certainly been arrested before for attacking him, the allegations that she's making clearly are not credible. I would ask the court to take that into consideration in setting his bond.
Okay, so I'm not so much concerned about because I'm either giving a signature bond. I'm more concerned about the girlfriend. Does the girlfriend live at that 643 Etheridge Street address?
She lived there, but when I spoke to her today, she told me that she's not going to be living there anymore. Because I think, she has connections with her family, so she has divided loyalty at this time, Your Honor.
Okay, so it's going to be for each count a $3,000 signature bond through pretrial, which makes it a total of a $6,000 signature bond through pretrial, 1-day anger awareness, no further contact with either Ms. Lewis or Ms. Kemp. He is, if Ms. Lewis and Ms. Kemp are not at the 643 Etheridge Street address, he can go back to that address. He's to go back there the first time with police escort, and if they are not there, then he can stay. If they are there, or either one of them, then he is going to have to collect his belongings and find someplace else to stay.
Your Honor, I just want to point out that this is his home. And when I actually spoke with the younger woman, the alleged girlfriend, she told me, she told my client that she was pregnant, but when I asked her about the pregnancy, she denies that she's pregnant.
Well, they're gonna have to work that out somewhere else because I mean, he'll have to have an eviction process or something if she, I don't know whether she lives there or not. But if she doesn't live there, if she's not staying there, then he can go back. If she does, then he's gonna have to collect his belongings at this time and, possibly go through the eviction process to get her out before he can go back. But since he's to have no further contact with either of them, and no contact means no contact whatsoever, Mr. Hughes. You can't have any contact with them whatsoever. Okay, no drugs, alcohol, or weapons while out on bond. Thank you, Ms. McLeod, Ms. King. Good luck to you, Mr. Hughes.
14, Mr. Knox.
Good afternoon, Mr. Knox. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? You're on mute, Courtroom Two. Yes, sir. Do you agree to have your case heard by video?
You gotta speak up so they can hear you.
Yes.
Okay, thank you, Mr. Knox. You've been charged in case 22 CR 004882C with battery family violence. Is there a history, Mr. Howard?
58 total. Last arrest was September 2021 for battery DV. He got an open simple assault and terroristic threats in state court, open battery and pandering in state court, and an open battery DV in state court. 2015 ag assault, simple battery conviction. Well, hold on. Simple battery conviction. 05 simple battery felony terroristic threats conviction. I'll leave it at that.
Okay, you're good. Thank you, Ms. King.
Yes, Your Honor. The state would like to note that he has 3 open cases, 1 battery family violence against the same victim, 21 CR 004984C, which he received a 5,000 surety last year. He also has an open battery and pandering, 21 CR 003790C, which he received a 2,000 split bond. He also has an open simple assault terroristic threats, 21 CR 003077C, where he received a 5,000 surety. They are in the process of revoking that bond. Actually, I'm not sure when that motion to revoke bond will be heard. This gravely concerns the state that he has open cases against this victim and some other unknown person, violent cases, Your Honor. On yesterday, the officers who dispatched to 979 Callahan Street Northwest in Atlanta. Officers met with the victim, Ms. Tanya Carr, and she advised that when she was sitting in the living room of their home, the defendant jumped on her. And she states this was without warning. They weren't arguing anything. He just jumped on her unprovoked and started to punch her in the face. The officer noted a busted lip and gums, swollen cheek, and bruising around her eye. When the officers asked if he was still in the home, she said, yes, he's inside sleeping. And when officers went inside, he was sleeping on the couch in the room. When the officers asked him what happened, he gave his version of the story, but it didn't line up with the injuries, definitely that the officer actually observed. The state is asking for a cash bond in this case, $7,500, and a stay away from 979 Callahan Street Northwest. No further contact with Ms. Tanya Carr, and her last name is 2 R's. And no drugs, alcohol, or weapons. He also has, outside of these open cases, he also has violent convictions, a simple battery conviction from 2015, as well as from 2005. 58 cycles, most of them being probation violations and FTAs and these violent offenses, which makes the state feel like a cash bond would be totally appropriate under these circumstances.
You don't know whether or not I gave him any of those bonds, do you, Ms. King? And if I did, was there no further contact associated with them?
Yes, so for the battery family violence against her, there was a no further contact and there was a stay away provision in that bond, the 21 CR case. I don't believe you gave him any of these, but I could be mistaken.
Okay.
And the others didn't involve her, so they don't have any conditions concerning her.
All right, thank you. Ms. Gant?
Thank you, Your Honor. Mr. Knox is 64 years old. He has been in the Atlanta, Georgia area his entire life. He has family, but of course, no one is available to help him with bond. Your Honor, Mr. Knox informs me that his address is the incident location. He states that Ms. Carr, the complaining witness, does not live there, Your Honor. Mr. Knox completed 8th grade, but he went on to obtain a GED. At this time, he is not working. He states that he broke his ribs. He's been out of work for about a month, and he was set to return back to work yesterday. Of course, he denies the allegations. He states that he was merely defending himself as Ms. Carr attacked him. I am requesting a signature bond. He doesn't have the means to bond out of jail. If Your Honor determines that he is ineligible, then I would ask for the lowest surety bond possible, no more than $1,000. And again, we are opposed to a stay away from his residence, Your Honor. We are unopposed to the no contact order. Thank you.
Okay, so it's going to be a $10,000 good bond, no further contact with Ms. Carr, stay away from the Callahan address, no drugs, alcohol, or weapons while out on bond.
Your Honor, may that stay away be a one-time law enforcement to confirm that, because again, he tells me that she does not live there.
She does not. She has been.
Mr. Knox, please remain silent, sir.
I'm sorry, Your Honor, just for clarification, what was the address? Ms. King, I don't know if you can give that information.
979 Callahan Street Northwest in Atlanta.
Okay. And Your Honor, just to let you know, you did sign that order on September 21st, 2021 for a $5,000 good bond, no further contact with Ms. Carr, stay away from 241. It looks like it says Troy Street, and no weapons, drugs, or alcohol. That was signed by Your Honor, and there was a previous order for the simple assault terroristic threats that was signed by Your Honor, $5,000 good bond, no further contact with Aldrich Lowe, no weapons, drugs, or alcohol. So Your Honor, at least from what I can see, signed 2 of his previous bonds as well.
Okay, thank you, Ms. Falk. I appreciate that. Ms. Gant, if that is his address, he may have a one-time escort with law enforcement to make sure that Ms. Carr is not at that address. If she is not at that address, then of course he can go back there. If she is, then he's going to have to gather his belongings and find somewhere else to go, okay?
Thank you, Your Honor.
All right. Good luck to you, Mr. Knox.
You got Mr. Knox.
What address I supposed to be at? What address I supposed to not be?
Raise your hand and ask him.
You gotta get up the chair.
No, he has a question. Raise your hand and ask the
Yes,
question.
sir. On what address am I supposed to be at? The one she got thrown out or the one that I'm staying?
Mr. Knox, I will give you a call at the jail, sir.
She gonna call you, Mr. Knox. Have a seat on the chair for me over here.
I apologize, Your Honor.
Johnson,
You're fine, Ms. Gant. Thank you. I'm sorry. Tell me again.
position 12, Johnson. Right here, Johnson.
Thank
Knox,
you.
this red chair.
Good afternoon, Mr. Johnson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You've been charged in case 22 CR 004876B with battery family violence. Is there a history, Mr. Howard?
6 total. Last arrest was in April. Probation violation. He's on probation in Glenn County for robbery. 2014, they gave him 5 years to serve and 10 years probation. Hold on. 2012 simple battery DV conviction. That's all.
All right, Ms. Falk.
Yes, Your Honor. This occurred on July 24th of 2020. The state did do a tolling order in the accusation, so that does preserve our time period based on the tolling time for COVID. The officers arrived at the location and spoke with Miss Ayanna Mitchell. That is IYANNA, last name Mitchell, common spelling. That's over at 2700 Camp Creek Parkway. Miss Mitchell had a small laceration to her right cheek near her lip. She also stated she had numbness to her back, and both of her eyes had were swollen. It was Miss Mitchell who stated that the defendant had struck her, and that was what resulted in her injuries. We did attempt to contact the victim. We did leave a message. We also sent a text message, but we have not received a response at this time. We are asking for a $2,000 surety bond that is based on the 2014 conviction out of Glynn County for simple battery, as well as a 2014 robbery conviction out of Glynn County where he received a 10-serve-5. He also was arrested in 2021 and 2022 for driving on an expired license. I believe one of those was a conviction, and he was arrested as recently as April 2022 on a probation violation out of Brunswick. So we do have concerns about his lack of ties to the community, or at least to Fulton County, as well as a previous history involving family violence. And for that reason, we are asking for that bond. We are further asking for no further contact with Miss Mitchell, 1-day anger awareness, and no alcohol, drugs, or weapons. Thank you.
Thank you. Ms. Gant.
Thank you, Your Honor. Mr. Robert Johnson is 34 years old. He has been in Atlanta for 1 day. He states that he is from Fort Valley, Georgia. Your Honor, my client tells me that he does not know this person. He does not know Miss Ayanna Mitchell. Therefore, he denies the allegations. We're unopposed to any stay away and no contact provisions. Your Honor, Mr. Johnson completed 12th grade. He is unemployed. He tells me that he was just released from jail, and he hasn't been working. He does not have a job. He doesn't have any means to pay anything toward bond. His history is pretty much remote. The last conviction that I heard is 2014. So just because, based on his ability to pay and just getting out of jail, losing his job, I would ask for that your Honor consider giving him a signature bond. This alleged incident occurred over 2 years ago. So I would ask again for a signature bond, Your Honor. Thank you.
And just to reiterate, although it was a traffic offense, his last conviction was 2022.
Okay. Given the age of the case, it's going to be a $5,000 signature bond through the jail. No further contact with Ms. Mitchell. Stay away from the Camp Creek Parkway address, and no drugs, alcohol, or weapons while out on bond. All right. Good luck to you, Mr. Johnson.
All right.
Thank you, Your Honor.
Mr. Madison.
Good afternoon, Mr. Madison. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir. Good afternoon.
Good afternoon. Mr. Madison, you've been charged in case 22 CR 004883F with battery, family violence, and 2 counts of cruelty to children in the 3rd degree. Is there a history, Mr. Howard?
The second arrest. Last was 2020, carrying weapons within the school safety zone. That's a felony that's open, 20 CP 189848.
I'm sorry, Mr. Howard, what's the felony?
Carrying a weapon within the school safety zone.
Okay, thank you. Ms. King?
Yes, Your Honor. On yesterday at around 11 a.m., officers were dispatched to 349 Lisa Court Southwest on a dispute fight call. Upon arrival, they met with the victim, Karaya Harris, Keareah, last name Harris. She stated that her live-in boyfriend, who was the defendant, had been arguing with her all morning. And she stated that she had been talking loudly in the home and he wanted her to be quiet. So he grabbed her by the throat and began to choke her, saying he would make her shut the F up. She stated that while being choked, she did not lose consciousness, but it was painful and she was trying to fight back. The officers noted visible cuts, a cut and swollen lip and bruising on her neck that corroborated what she stated. The officers called EMS, but she declined getting treatment at the scene. The officers also noted that there were 2 children present, a 6-year-old Bartholomew Alexander and a 5-month-old Jeremiah Madison Jr. that was present at the scene. After the incident, the defendant actually took the child and went to a family member's house. But while the officer was there investigating, he returned with the child unharmed, which is when he was taken into custody. We have been in contact with this victim and she states that they are in a relationship, live together and share a child. Even though the facts are pretty horrible, she was stating that it's not a big deal. We believe that the victim is in the cycle of violence, and due to that, we're gravely concerned for her safety. She did confirm that he did strike her and grab her around the neck, and the bleeding and the bruises were due to the altercation they had with each other. Where the state is requesting a $7,000 surety bond, that's $5,000 for the battery family violence and $1,000 for each of the cruelties. No further contact with any of them, Kariah Harris, Bartholomew Alexander, or Jeremiah Madison Jr. A stay away from the 349 Lisa Court Southwest in Atlanta, and no drugs, alcohol, or weapons while out on bond.
Ms. Kim?
Yes, Mr. Madison is 26 years old and he has been here in Georgia for all his life. They have a 1 child together, that 5-month-old Jay, I'm going to just call JMJ, is their child together. He has separate child. She has another child. They do live together, and actually they are planning to move to another house as a couple. They're engaged right now. They plan to marry, and right now he is employed as a truck driver. He's been employed for the last 5 years. He graduated from high school, and also he's enrolled to get automotive technical license or certification. And we would like to request for a signature on bond. And yet, if your honor is not inclined to give him a signature on bond because of an open case, which he is presumed to be innocent. Actually, about that case, he didn't do anything. It was just car that was parked there, and inside of the car, when he was not even around, that's what happened. His weapon was found, but the car was parked. He was not even around, and he's not guilty of that charge at all. And we would like to request for a signature on bond. Thank you.
Okay, I see a Miss Madison on the line. I don't know if you are involved in this matter. If you are, can you tell me who you are? And if you would like to address the court, I'll have to swear you in. Ma'am, Miss Madison, did you hear me? Does anyone know who this is?
It's my mother.
Oh, okay. Thank you, Mr. Madison.
She said she can't hear you.
So she doesn't have her audio turned on, Judge?
You're gonna have to turn your audio. Well, I guess.
So, ma'am, you may have to log out and log back in, and when you come back in, turn your audio settings on. Because I can see that you don't have your audio turned on. Oh, but she can't hear me either. So I'll see if I can send her a message. Yeah.
Okay. That was from. Okay. Okay, I'm sorry, Miss Madison, we can't hear you. Does he, so has anyone spoken to Ms. Harris?
Yes, yes, we have been in contact with her. And the statement regarding that it's not a big deal, that's what she told our victim witness advocate. But she did confirm that the altercation happened, that he did put his hands around her throat. The injuries that she had is due to the altercation with him.
Okay. So at this time, it's going to be for the battery, $1,000 good bond, for each of the cruelty to children's, a $500 good bond, making it a total of a $2,000 good bond. Given the allegations, I'm not comfortable putting them back into the household at the present time. So no further contact with Ms. Harris. Stay away from the incident location. He can go back to that location on one occasion with law enforcement to retrieve any belongings that he may have there. And he has to have a third-party contact with the with his children for visitation. All right. Good luck to you, Mr. Madison.
Thank you.
Position 1, Adams.
Good morning.
Good afternoon.
Good afternoon.
Good afternoon, Mr. Adams. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Adams, you've been charged in case 22 CR 0048881Y with battery family violence. Is there a history, Mr. Howard?
This is 11th adult arrest. Last arrest was in February for trespass. On probation for trespass out of Lamar County. Out of open sale of marijuana and obstruction out of the cab. He has a Barnesville hold. February 2022 FTA conviction. December 2021 trespass conviction. April 2021 driving without a valid license arrest. FTA for obstruction 2019. 2019 probation violation, simple battery. 2019 trespass, NOLO. 2018 disorderly conduct, obstruction, conviction. And he got first offender for the simple battery in 2018. Got history out of Michigan. 2015 assault. Oh, that's the juvie. Never mind. That's it.
Okay. Mr. Dudley?
Yes, Your Honor. This incident occurred on July 25th, 2022 at 897 Parsons Street Southwest in Atlanta, Georgia. The victim, Jasmine Dent, common spelling, stated her and the defendant were in a verbal altercation. During the argument, the defendant slapped Ms. Dent across the face and pushed her onto a nearby bed. He started punching her repeatedly. Ms. Dent tried to defend herself, but the defendant continued hitting her. She tried to get away, but the defendant made her come back into the home. At some point after the incident, she was able to make her way to a bathroom and contact her case manager, Helen Payne, common spelling for the first name, Payne for the last name. She informed Ms. Payne of the incident, and Ms. Payne went and picked up the victim and went to a nearby gas station to call the police. Once the police arrived at the nearby gas station, the officer observed a knot on Ms. Dent's forehead and contusions to her face. The defendant was charged with battery family violence. Our recommendation is a $5,000 surety bond with no further contact with the victim. Stay away from 897 Parsons Street Southwest in Atlanta, Georgia, and no alcohol, drugs, or weapons while on bond. The reason for this recommendation is we have a concern that the defendant will influence the witness, as the defendant and the victim live together and are in a relationship at the time of the incident. And we were able to get in contact with the victim, and the victim stated that she does fear the defendant and wants no contact and stay away from the incident location. And she stated that the incident location is her home. And we also have a concern that there's a risk of reoffending. The defendant has been arrested for a simple battery on 2 prior incidences in Clayton County in 2018. Also, He's been arrested for criminal trespass in 2019. Both the 2018 simple battery and the 2019 criminal trespass were not against the same victim, but Your Honor, they go to show that the defendant has an anger management issue and a propensity for violence. We also have a concern for his lack of ties to the community considering his criminal history from Detroit, Michigan for the up to year 2015. That's why we are recommending the $5,000 surety bond, Your Honor. Nothing further from the state.
Thank you. Ms. Gant.
Thank you, Your Honor. Mr. Daryl Adams is 21 years old. He has been in the Atlanta, Georgia area for 5 years. He is the proud father of a 12-month-old son. He does not share the child with the complaining witness, Ms. Dent. Mr. Adams completed high school. He is currently enrolled in college, majoring in business management. He is employed at Atlanta Peace Movers. He has been in this position for the last 4 years, and he's very concerned about losing his job. Your Honor, he does not have anything to pay toward bond. I am asking for a signature bond on his behalf so that he may be released to the hold in Barnesville. And Your Honor, he denies the allegations. I did reach out to Ms. Dent, but she did not return my phone call. I left a message for her. So he wanted contact, and on my client's behalf, I am opposing the stay away and the no contact orders. However, we will defer to the court's ruling. Thank you, Your Honor.
All right, it's going to be $1,000 good bond. No further contact with Ms. Dent. Stay away from the Parsons Street address. No drugs, alcohol, or weapons while out on bond.
Good bond.
Good luck to you, Mr. Adams.
Position 17, I'm sorry, position 7, Mr. Hamilton.
Thank you so much. I have a nice one.
Do the same. Good afternoon, Mr. Hamilton. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Mr. Hamilton, you've been charged in case 22 CR 004875G with fair evasion and criminal trespass. Is there a history, Mr. Howard?
25 total. Last arrest was 2021 for shoplifting out of Chambly. 2015 probation, another 2015 probation. 2012 probation. 2012 possession of a Schedule 1 controlled substance. Another 2012 probation. 2009 forgery in the first degree conviction. I think he got a hold out of Chambly. He got history out of South Carolina. But the last arrest there was 2008. That's it.
Ms. Falk?
State's recommending a $3,000 signature bond and that the defendant stay away from MARTA until September 5th of 2022, which is the date his active suspension ends. We are also asking for no alcohol, drugs, or weapons. Defendant was observed pushing through the gate to avoid paying the fare, and had already had an active suspension that was issued on June 7th, 2022, which activated on July 7th of 2022 and extends to September 5th of 2022. Finally, I'm not sure if the active suspension, and I'm not sure if anyone can answer this for me, is just from this particular MARTA station or all MARTA stations. I will say that the particular MARTA station was Ashby MARTA station at 65 Joseph E. Lowry Boulevard.
What's that breakdown, Ms. Falk?
$1,500 per count. Again, that's a signature bond.
Okay. Any objection, Ms. Gant?
No, Your Honor. Thank you.
All right, so it'll be a $3,000 signature bond through the jail. No drugs, alcohol, weapons, abide by any active suspensions. And Ms. Gant, I guess he's going to have to make sure that if those active suspensions are for all of MARTA or just for that one station, but he's to abide by whatever MARTA suspensions that there are. Okay.
Yes, thank you, Your Honor.
Okay. Good luck to you, Mr. Hamilton.
All right, thank you.
Position 10, Hooper.
Good afternoon, Mr. Hooper. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Hooper, you've been charged in case 22 CR 004879D with criminal trespass. Is there a history, Mr. Howard?
It's his second adult arrest. 2017 suspended registration.
Mr. Dudley?
Yes, Your Honor. On July 28th of 2021, Officer Louis Jones responded to a call at the parking lot of Kroger Supermarket located at 1715 Howell Mill Road Northwest. There, the victim, Maurice, spelling M-A-U-R-I-C-E, Wallace, common spelling, stated the incident occurred on July 27, 2021, the prior day on I-75 southbound expressway northwest near the Howell Mill Road Northwest exit. Mr. Wallace stated that he and the defendant were in a verbal dispute when they were on the shoulder of the highway. The defendant exited the vehicle and walked to the rear and struck the window 3 times with his fist, causing it to shatter. Mr. Wallace stated that Lorenzo, the defendant, then jumped and scaled the wall on the shoulder of the highway and went over it in order to flee. Your Honor, there is a concern of influencing the witness, considering that the victim and defendant were in a relationship at the time of the incident. And we were able to get in contact with the victim, and the victim stated that they were no longer in a relationship, and they have had some contact since this incident. I believe he may be present in this Zoom, if I'm not mistaken. There is also a concern for a flight risk, as the defendant has 2 arrests in Michigan up to the year 2011. And although that this incident happened about a year ago, it's still pretty significant, considering that a verbal altercation led to someone's windshield being smashed with their bare hands. And for that reason, Your Honor, the state recommends that the bond remains set at 1,000 surety. And we recommend anger management, stay away, and no further contact with the victim.
Ms. Gant?
Thank you, Your Honor. Mr. Lorenzo Hooper is 26 years old. He has spent in the Atlanta, Georgia area for 6 years. He has family here. Mr. Hooper has a high school diploma. He is currently enrolled at Kennesaw State University. He's majoring in mass communications, and he aspires to own a PR firm one day. His GPA is 3.0. At this time, Your Honor, Mr. Hooper is unemployed and has been so for the last 1.5 months. He tells me that he does have an interview coming up with the IRS. Your Honor, my client denies the allegations. He's presumed innocent. I did have the occasion to speak to the complaining witness, Maurice Wallace. He states that he wants to continue having contact with him. Therefore, we are opposed to any stay away and/or no contact provisions. Thank you, Your Honor.
And I see that, Mr. Wallace, if you would like to address the court, now is your opportunity. You do not have to, but if you would like to, I'll need for you to unmute yourself and I'll have to swear you in.
Okay.
All right, can you raise your right hand for the court? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can put your hand down, sir. Thank you. What would you like to tell the court?
That it was just a mistake. Me and Lorenzo have reconciled, and we still have contact, and he's a good guy. It was just, a mistake, and I'm not concerned for my life or anything like that. And it wasn't my intention for him to go to jail on this incident. I was just trying to get the information to my insurance company, so.
Okay, thank you, Mr. Wallace. It's going to be $1,000 signature bond through the jail, no further violent contact with Maurice Wallace, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Hooper.
Thank you, Your Honor.
Position 3, Dockery. Have a seat, have a seat.
Okay, so I think this is the one that we
It
need to
is,
go
Your
into the
Honor.
breakout room. We're gonna have to have a discussion, courtroom 2 with him in the breakout room. Do you have anybody else in courtroom 2 that we need to address?
Yes, position 5, Gordon.
Do you want to go to position 5 first and then come back to Mr. Dockery?
This is position 5, Gordon.
Okay, thank you. Good afternoon, Mr. Gordon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video to help prevent the spread of the virus. You agree to have your case heard by video?
Okay.
Yes.
Yeah.
Okay, thank you. Mr. Gordon, you've been charged in case 22 CR 004849J with simple battery and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
49 in total. Last arrest was January for simple battery. That's open in state court. 2020 FTA disorderly conduct. 2019 trespass. We got obstruction conviction 2017. 2017 FTA for felony obstruction. Did we do this one yesterday?
Yes, Your Honor, this is one where there was a reset and appeared before Your Honor yesterday.
Okay, thank you. Thank you, Mr. Howard. Ms. Falk, will you remind me?
Yes, Your Honor. So this happened on July 23rd. Officers were dispatched to 2177 Baker Terrace Northwest in Atlanta. They spoke with the victim, Deontay Gordon, who stated his brother, Kendrick Gordon, had pushed him and kicked him in the face around 9 p.m. that evening. They also spoke with Miss Helena Gordon, who stated that the defendant had punched holes in her home and was being destructive in the household. Officers went and observed the defendant sleeping on the couch, had to do sternum rubs due to the defendant being intoxicated to rouse him. They then tried to speak with him about what happened, and he attempted to walk away, but they stated they still needed to speak with him to complete the investigation. He then shoulder bumped the officer and kicked the officer in the left leg, at which point the officer placed him under arrest. At that time, he had to pull out his taser because he was unable to get the handcuffs on the defendant. The defendant was trying to resist arrest. He was able to put his taser back and take the defendant to the ground and handcuff him. Once he was detained, the officer actually observed the defendant give a kick to his brother while his brother was standing there, which is actually the basis for the simple battery. So the state's recommendation in this case, I believe the defendant was given, I want to say a $7,500 surety bond, but let me just double check on that. Because I'm not entirely sure if that is correct.
It's correct.
Okay, so the defendant, thank you, Ms. McLeod. So the defendant was given a $7,500 surety bond. So here are the state's concerns. We have a defendant who has been, was born in 1991, and he has over 40 cycles. So at this point, he literally has more cycles than he's been alive. Add to that, that actually, according to pretrial, and we actually pulled this up, the case of simple battery is not an open case. He actually pled guilty to that case, that it was 22 CR 000421C. That again involved his brother. And that incident occurred, that plea was taken on, let me just double check, February, I believe this says February 15th, 2022. And he was given 12 months to serve 30 days, credit for time served, balance probated, no further contact with Deontay Gordon, and stay away from the same address that he was at on this incident. Add to that, that when we tried to contact the victim in this case, we spoke with the grandmother of I believe it was the grandmother, I'm sure what the victim advocate will correct me if I'm incorrect, who tried to prevent us from talking to the brother, the victim in this case. Then we received a voicemail from the victim where the grandmother can clearly be heard in the background coaching the victim, and the victim saying he doesn't want to go forward with charges. So there is influencing a witness. There is risk of reoffense. He has actually violated his probation with this new charge that he was just given not even 5 months ago. Basically, if it can meet an IALA factor with the exception of flight risk, it has met an IALA factor. So for that reason, we are asking that the bond remain the same. I I don't know if we gave a breakdown as to that, but I would say it'd be 5,000 on the simple battery, $2,500 on the obstruction of the officer. We are also asking again that he stay away from that address. Again, that's already on his probation, but we'd ask again, he stay away from the address and that he have no further contact with the victim on this case and no alcohol, drugs, or weapons. Thank you.
Hey, Ms. McLeod.
Yes, Your Honor. My client denies that he was the one who initiated this altercation with his brother. He tells me that both him and his younger brother, who's the alleged victim, have lived with their grandmother for the past 8 years. He tells me that he's currently unemployed. He also tells me that he has nowhere to go. So essentially, if he cannot go back to that address, he will be homeless. And I just wanted the court to be aware of that. He doesn't have any money, and he has no one who's in a position to help him pay bond. That being said, I'm just asking the court to take these factors into consideration in setting a bond for him. $7,500 for him, given his current circumstances, simply means he'll be sitting in jail for the foreseeable future because he's in no position to post bond, Your Honor. And I just wanted to ask the court to take that into consideration.
Okay. My issue, Mr. McLeod, thank you. I wanted you to be here. And that's why I reset him from yesterday so that he would have some counsel to represent him. I do not remember from yesterday, Ms. Falk, that he was already on probation for a similar offense and that he already had to stay away from that address. And although I'm very sympathetic, Ms. McLeod, to his situation, if somebody else, if he's already said and pled guilty, so those aren't allegations. If he's already pled guilty and a part of the sentence said that he couldn't go back to that household and that he could not have any contact with his brother, then he's going to have to abide by that.
I understand, Your Honor. I fully understand. I was unaware that there was a stay away order until it was said just now. Right.
And so he's going to have to make other arrangements because he's already agreed to make other arrangements. I'm going to leave the bond where it is right now, the $5,000 for the simple battery and the $2,500 for the willful obstruction. He's going to be back before me on August 9th on the SAP calendar. And I don't know if you can, if you'll have anything more for me at the SAP calendar regarding his living arrangements or anything of that nature. But if you do have something else, or whoever represents him does have something else for me at that time regarding these living arrangements, I'm happy to revisit the bond if there's not a plea in the case, okay?
Thank you, Ronald.
So we'll leave it where it is today with all the conditions that I set yesterday, which I'm sure was no further contact, stay away, and no drugs, alcohol, or weapons while out on bond. Okay?
Thank you, Your Honor.
All right.
Thank you, Ronald.
And let's see, Courtroom Two, if you don't mind, I know that we only have one at the South Annex, and I'm going to have to speak on that last client for a minute. If we can go to the South Annex and just do the one that they have at the South Annex, and I'll come right back to you. Okay?
Good afternoon, Your Honor.
Good afternoon. This is Position 15, Ms. Marks.
Yes, sir.
Okay, good afternoon, Ms. Marks. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, good afternoon.
Good afternoon. Ms. Marks, you've been charged in case 22 CR 004880J with simple assault, family violence. Is there a history, Mr. Howard?
First arrest.
Mr. Dudley?
Yes, Your Honor. This incident took place on July 25th, 2022 at 195 Fairburn Road, Atlanta, Georgia. The victim, Demetria Thornton, spelling of the first name Demetria, Thornton, Thornton, flagged down Officer Katib. She stated that she was in a verbal argument with the defendant during the altercation the defendant began to push Ms. Thornton and take the defendant's 3 to 4-year-old child away from her. The victim pointed out that the defendant was walking in the parking lot. So the officer went over to the defendant to try and get the defendant's side of the story. The defendant decided that she did not want to give a statement. However, she did tell the officer that if Ms. Thornton comes over here, I'm going to fight her. The officer made numerous attempts to calm the defendant down. And when Ms. Thornton walked over to the officer and the defendant approached Ms. Thornton in an aggressive manner with a closed fist. And if it had not been for the officer, Ms. Thornton would have been hit by the defendant, but the officer stopped the defendant from hitting Ms. Thornton. And once in custody, the defendant stated that she was going to pay someone to kick down Ms. Thornton's door and beat her while taking her 3 to 4-year-old child away. Your Honor, there is a concern with the state that there is an influence for the witness. We are unsure of the relationship that exists between the defendant, the victim, and the defendant's child at this time. We did attempt to reach out to the victim. We called and we left a text, but we were unable to reach the victim at the time. So with these factors, Your Honor, we recommend a $2,000 surety, stay away from address, and no alcohol, drugs, or weapons while out on bond.
All right, thank you, Mr. Dudley. Ms. Kim?
Yes, Ms. Marks is 19 years old, Your Honor, and she was born and raised here in Georgia. And KM is her daughter. And the story is completely different from what I hear from the warrant. Even the warrant clearly states that complaining witness Demetria Thornton, who is my client's mother, she was holding a hammer, Your Honor. My client was shocked, scared, and my client told me that her mother choked her neck, and this was not something that she initiated. It was mother who was an initial aggressor, and she was simply defending and wanting to have her child with her. And it happened, but she's gonna go to somebody else's house. So she doesn't oppose to stay away from 195 Fairburn Road, where her mother resides. She will be going to her father's place to stay there, which has a different address, 79 Hallwell Drive. And she has an employment at McDonald's. She's been working there for 3 weeks. She does not want to lose that job because she really needs the job to continue to support her and her child, since she does not get any child support for 3 years old, 2.5 years old baby. And she is still going to high school. She's returning this August to one final semester at the high school. So she wants to graduate from her school. We would like to request for signature on bond, Your Honor. Thank you.
Your Honor.
Yes, Mr. Dudley.
I would like to make it known that Ms. Thornton has been the caretaker of the child since the child was born, and that the defendant was trying to take the child away from Ms. Thornton.
Okay. So, Ms. Kim, your client has her hand up.
You have every right to remain silent. I recommend you to stay silent. I want to explain that Thornton Demetria, she actually babysat the child sometimes. She was not raising him from the birth. That's not the truth. So we deny the allegation, Your Honor. Thank you.
Okay, you can put your hand down, Ms. Marks. So
And I'll call you.
We'll see you there. I'm going to give you a signature bond, Ms. Marks. Okay, so it's going to be a $2,000 signature bond through pretrial, one-day anger awareness class. No further contact with Ms. Thornton, and to stay away from the Fairburn Road address. No drugs, alcohol, or weapons while out on bond. I don't know anything more about the child, so they're going to have to deal with the child through some other court system.
Your Honor, just to let the court know, the DFAX was contacted by the officers.
Okay, so, and it'll be also and abide by any DFAX orders.
Yes,
Okay.
Your Honor. May she have a one-time law enforcement officer visit to take her personal belongings? For example,
Of course, you can
Yeah.
have a one-time escort at 195 Fairburn Road to retrieve any of her belongings that might be there.
Thank you.
Again, Ms.
What was
Campbell,
the amount, Your Honor?
it's a $2,000 signature bond through pretrial.
Yes, sir. Okay.
No,
Ms. Marks, you're getting a signature bond, so you're getting out, and with everything else, you can discuss it with Ms. Kim, okay?
yes, I'll call you.
All right, so thank you, South Annex. I think that completes the South Annex.
Yes, Your Honor.
All right, we'll see you next time. So back in courtroom 2, we have Mr. Gordon, and we're gonna have a breakout room for Mr. Gordon. So Ms. McLeod, I'm not sure I know Ms. Falk.
That is correct, Your Honor. I also want Mr. Dudley to accompany us. Before we go in, I would just ask that pretrial put as much of the history they can sound on the record, just so Your Honor knows his history before we go into the breakout.
Okay, Mr. Howard's standing in here with me, so.
31 total.
Can you all hear it?
Yeah, or we can do it in the
I
breakout.
heard
either way.
31 total.
Okay, but I did hear 31 total.
Yeah. Last arrest was August 2021 for robbery. He's on probation for robbery by force / intimidation. It's 12 SC 114822. 2013, they gave him 2 years to serve and 8 years probation. The robbery by intimidation is 10 SC 94221. They gave him 2 years to serve and 18 years probation. Yeah, and he got a robbery by intimidation. What is this? 21 CP 202657. Also has history out of Florida. 2019 probation violation. Yeah, the 2018. Hold on. He had sexual battery 2018 conviction. Disorderly conduct conviction 2018. Criminal attempt to commit a felony. Shoplifting conviction 2015. Trespass conviction 2015. 2014 probation. The robbery and the batteries from 2012. I think that is it. Oh, we had the 03 battery conviction. 03 criminal interference with government property conviction. That's it.
Okay. So let's go into the breakout room. Okay, Courtroom Two, thank you. The bond's gonna remain the same at a $5,000 cash bond. And he's gonna have a mental health evaluation ordered also, okay?
Thank you, Your Honor.
Thank you. Y'all have a good, I think that completes everyone, right?
All right.
All right, have a good day. We'll see you next time. Okay, so Ms. Bridgewater's here with me, and whenever she's ready, we'll go over the calendar.
Good afternoon, and once again, the reset date for the SAP calendar is going to be August the 9th. Position number 1 is going to the SAP calendar with a $1,000 good bond. Position 2 is also going to the SAP calendar with a total $8,000 good bond. Position 3 is going to go to the competency calendar with a $5,000 cash bond. Position 4 SAP calendar, $3,000 good bond. Position 5 reset to the SAP calendar with a $7,500 total good bond. Position 6 reset further notice with a $3,000 SOB through pretrial. Position 7 reset further notice with a total $3,000 SOB through the jail. Position 8 is going to go to the SAP calendar with a total $3,000 good bond. Position 9, SAP calendar with a $3,000 good bond. Position 10, reset further notice with a $1,000 SOB through the jail. Position 11, reset further notice with a total $6,000 SOB through pretrial. Position 12, reset further notice with a $5,000 SOB through the jail. Position 13, reset to the SAP calendar with a $7,500 good bond. Position 14, the SAP calendar with a $10,000 good bond. Position 15, reset further notice with a $2,000 SOB through pretrial. Position 16 is going to the SAP calendar with a total $2,000 good bond. Position 17, reset further notice with a $3,000 SOB through pretrial per judge. Position 18, reset further notice with a $3,000 SOB through the jail. Position 19, reset to the SAP calendar with a $2,000 reset to the SAP calendar with a $2,000 total good bond. Position 20, SAP calendar with a $5,000 total good bond. Position 21, SAP calendar with a $1,500 total good bond. And position 22, reset further notice with a $4,000 SOB through the jail. Any questions, comments, or otherwise?
Let's revisit 13.
13,
I have a $3,000 good bond.
for 13, this is Quentin Jones.
Yes. Whose client was that?
Cloud.
Does anyone have any notations that either confirm or deny either of those?
I have 7,500 good bond, Your Honor.
Okay, so it's my mistake. And that was your client, Ms. Kim?
Conflict case.
Okay, do you have a note on that, Ms. McLeod?
Yes, Your Honor. It's 7,500 good bond and the order for mental evaluation.
Okay, all right, thank you.
And can we cover position 8? I missed that one. I just want to make sure I have that correct.
Yes, it's going to the SAP calendar with a total $3,000 good bond. That's $1,000 on each chart.
Okay, thank you.
You're welcome.
Okay. Anything further? If not, you all have a good rest of your day. We'll see you next time. Thank you.
Thank you so much, Your Honor. Have a good day.
Have a good day.